Okay. Looks like we're live, Emily.
It's looks like it's starting to make the link happen.
Okay.
Make sure. Okay, I think we are.
Okay. Well, then let's go ahead and get started. Like I said, thank you everybody for being here. Whether you are a surrogate, a intended parent, a representative, a senator, a supportive constituent, thank you so much for taking the time to be here today. I want to get started by kind of explaining what gestational surrogacy is. In some of our lead up to this point, we've been hearing some reference to traditional surrogacy. But I want to take a moment to just distinguish the difference between the two, because we are all here today to help support gestational surrogacy. Traditional surrogacy, what that looks like is
Oh, that's way worse.
background.
Sorry, Liz.
That's okay.
Well, can they see
Hey
us?
everyone, can we have you please mute your phone when you're not speaking? Thank you.
Okay.
Sorry,
Perfect.
go ahead.
That's all good. Okay, traditional surrogacy is when, before science brought us to where we are today, this is where the woman who was carrying the child in the intention for another family to adopt, it was actually her biological child, where it was her egg and then the male cell, and then she was actually giving up her biological child for adoption. And in more recent times, and thanks to modern medicine, we really don't ever see this form of surrogacy anymore. And actually, many states outlaw this sort of surrogacy just because regulating this sort of arrangement was very difficult. And so we are going to only be talking about gestational surrogacy, and that is the form of surrogacy that we all have a personal connection with that's here today. And what this looks like is the surrogate or gestational carrier has no biological connection to this child. This is where an egg and sperm have been fertilized outside of her womb and then transferred to her safe uterus with the intention of giving up this child to the intended parents. So she has no biological connection to this child, and she never intends to be the parent of this child. Before any of that takes place, there are months of preparation that happen before a pregnancy ever occurs. So I want to take a moment to just talk about the process, because I believe that's really why we're all here today, is our surrogacy contracts and the provisions that you'll see in those. And I believe Emily is going to be talking about the contracts a little bit more in detail, but I want to talk about the process of leading up to the contracts. So I'll explain this from kind of my personal background, because mine is much like most that happen in South Dakota. My husband Gavin and I, we knew that we needed to use surrogacy to grow our family. We knew that I had indefinite infertility. And so when we were ready to grow our family, we actually met our surrogate through a mutual friend. She had been a surrogate one other time, and she worked with an agency out of Maple Grove, Minnesota. Because of her experience as being a surrogate before, we were referred to each other through a mutual connection. When we had already, Heidi and I had met and we had talked about, how we want our arrangement to look and, her expectations and my expectations, we immediately connected. We knew it was like God's work. It really was. We spent 6 hours on a couch together and getting to know each other, and we were immediately like sisters. But that was the easiest part of the whole piece of it, because we went to Sanford, and Sanford actually has to deem intended parents qualified to be intended parents. Not just anybody can become an intended parent. So what this looks like is they need to determine you are indefinitely facing infertility. And once they did that, they said, okay, once you have found your gestational carrier and you have completed the contract, you can bring that back to us. And at that point, we will have to medically clear your gestational carrier. So I had already known that we were going to be moving forward with Heidi. And this is where things can be different for everybody. This is where an agency really is key for being matched with a safe and trusted gestational carrier. But we had already done that. And so what we did was we started the process to our contract. And what that looks like is the surrogate and her husband, if she has one, or spouse, if she has one, must find an attorney that is well versed in reproductive medicine or surrogacy, as well as us. So we have separate legal representation, and both attorneys should have thorough experience with assisted reproduction or surrogacy specifically. In South Dakota, we have 4 attorneys. Emily Galing, she's on our call now. She was actually our legal representation. And I believe it probably took us 3 months to draft our contract. It started with Emily, and this contract is detailed. There are details as small as whether or not she can have a cup of coffee, our gestational carrier. How many cups of coffee would I be okay with her consuming while she's pregnant with our child? Whether or not she can dye her hair, get a manicure, small details like that. Details that have to do with how far she can travel from her home or the hospital that she plans to deliver. Details that Heidi, our surrogate, her husband, Chad, my husband, Gavin, and I, we talked about at length. So not only did we talk about this, but Emily helped us outline this in our contract, just to ensure that we have a conversation about every detail. This outlines things also as far as custody, the chain of payment for medical bills, what that's going to look like. We actually used an outside savings account where Heidi would pay for her medical bills, and then she would give the receipt to the savings account and they would cut her a check. It was the middleman. So our contract outlines those details. Our contract outlines custody, which is, it can vary by state. This is a crucial piece of our contract where they say Heidi is pregnant with our child. The intended parents, Gavin and Elizabeth Waltage, will be the parents of this child and assume all financial and physical responsibility for this child. Ours, I believe, was 37 pages long. This is not only drafted by our attorney, but then it's looked over by her attorney and talked over with Heidi and Chad, and we sign off on every provision. So the provision that brings us here today is a matter of pro-life. Our surrogate signs off on a provision regarding reduction, and what it states is that she will only partake in a reduction if and only when a team of doctors deem it necessary to saving her life. And really what this acts like is almost like a do not resuscitate provision, like many of us have. It's a document that all of us have talked about thoroughly and signed off on, so that in the moment of an emergency where emotions are heightened and maybe she cannot speak on her behalf, like for example, right now during COVID, when the doctors are going to turn to a document to act on the behalf of all of their wishes. Because of that provision, we are not outlining an abortion. We are outlining how to save life, preserve life. And I'd like to share an example. My cousin, who had faced 10 years of infertility, she lives in Denver, Colorado. Her placenta detached by 80%, and she was bleeding to death. And she was on the table, and the doctor said, we need to abort this pregnancy. She's going to die. And because of her contract, that wasn't an option. She would have delivered the baby and allowed for her life to end in all ways to save her baby. but her doctors turned to this document because her husband wasn't there. There wasn't an advocate there. And so that is what our contracts are outlining. Now, I know that you guys have been shown other contracts that might have things in there on the contrary. And when it comes to reduction, all of us are going to have different opinions on this, but what I'm here to outline today is that these contracts are a very personal written explanation to essentially 2 to 4 parents' wishes that we talk about in depth, because this is such an intimate and personal journey. It's important that before a single medical procedure takes place, that we talk about every possible thing that could happen. So to say that there's coercion it's hurtful, because what we are doing is thinking about every circumstance that could possibly impact our child, and this contract is our way to know we're all on the same page. How many other arrangements do 2 to 4 parents talk about their journey to parenthood in this detail prior to even creating the child? So that outlines our contract a little bit before we even have a medical procedure with our surrogate. But also what Sanford requires is that all of us involved, the surrogate, the intended parents, and the surrogate spouse, if she has one, we undergo a psychological evaluation. And more or less during that psychological evaluation, we go through the provisions that are in our contract just to highlight the emotional and mental connection to those provisions. And this psychologist deems everyone involved appropriate to enter into this relationship. Not only that, our surrogate goes through a medical screening prior to any sort of attempt for pregnancy to ensure that she is medically safe for that embryo to be placed into. And the qualifications for a surrogate, I mean, we refer to surrogates as unicorns because it's very specific to who can even be a surrogate. And that's to ensure that when that embryo is placed into that uterus, that baby has the best ability to thrive. So our surrogates have to be between the ages of 21 and 40 years old. The surrogates, they should fall into an area of a healthy BMI. They had to have had at least one child of their own to ensure the medical precautions that go into the pregnancy, that she is free of, I guess, fears of her pregnancy, meaning she couldn't have had preeclampsia or gestational diabetes. She could not have had more than 5 children prior, and a multitude of other things that would qualify her to be a surrogate. So not only are we doing everything in our power to be safe leading up to the transfer, but we want to make sure medically that our embryo is going to be safe in that uterus. And so I just really wanted to outline the process beforehand to say coercion is not happening here. All of our wishes are outlined in detail in our contract and signed off on by all parties prior to a medical procedure. Now, the things that are in our contract, you know, some people feel it's okay to have coffee during pregnancy. Some people don't want to have any caffeine at all, but we have that conversation. It is to the smallest of details. And, you know, it's just impossible that everyone here at the table is going to agree on all of these things. But what I really would appreciate someone to consider is that we are all medically, mentally, and socially screened to make these decisions on our behalf. And I promise you, I am not spending my life savings, working 2 jobs, taking out loans, and maxing out every financial possibility that I can to create life. Our surrogate is not putting her whole life on the line and whatnot to create these families to just end the life. That is not it. These abortion provisions, I can't even call them that. These are pro-life provisions to outline what we would do in emergency circumstances. And really, it doesn't go beyond that. So I'd like to take a minute to offer up a window of time for questions. I'm sure that was a lot of information. And we want to break it apart as much as we can so that you can ask the questions that you need.
Liz, this is Jennifer. I have
Hi.
a question. Hi. For you, or if others want to answer too, I'm curious, what is the biggest objection that you're hearing from people, from legislators that you're talking to about this?
The biggest objection that we're finding right now because of Senate Bill 183 is that there's this tone of coercion happening, that women are being forced to have an abortion, or that there's some sort of nature of coercion happening in this contract. And I believe that's really what everyone is trying to prevent. But also, you know, even the fact that abortion is discussed or reduction is discussed is people being fearful of worst case scenarios or extreme circumstances that really aren't happening in South Dakota. There's, in 30 years, there hasn't been one legal case regarding any of these issues or provisions in our contracts. And
This is Senator Rush, and that's, you know, we heard in committee, we had some contracts that were read to us that did include those provisions, and they were South Dakota contracts. Now, whether they resulted in forced abortions or not, I can't say that, but there are some people that, some lawyers who are doing these that are including those in the contracts. And, you know, I don't know that anybody's concerned if those are not being included in the contracts, but if they are, by anybody, and it may not be, you know, the people that you're working with, but that's the concern. You know, certainly don't want to make it a crime to discuss that, and I don't know that it does, but you know, I just finished looking back over this 183A and 183C, the two proposed amendments, and I didn't detect in either of those that made it a crime to discuss the abortion, but it may C is A is maybe a little bit clearer that just that provision of the contract is unenforceable. So, you know, I guess there is a concern because there have been contracts written in South Dakota that do require abortions.
yeah,
In,
Julie,
re-
you wanna
in,
talk
in
about
regards to that, contract, Senator Rush, I can tell you that as a gestational carrier myself, everything that is in my contract is something that I and my husband read and that we signed off on. During the point of our contract, we were not allowed to discuss any of the details with the intended parents. We weren't actually allowed to talk to each other. I had actually had a surrogacy contract prior, and then COVID kind of interfered with it. And so I wanted to pursue it with another family. So my contract phase for my second process went a lot quicker because my attorney was the same one that I used prior. And she mimicked my agreements exactly. So what are in those contracts and what Senator Schoenbeck showed at committee is something that gestational carrier herself agreed to. No one's forcing anyone to sign the contracts. One of the things that we were hearing was that we as women were being coerced and due to a financial prospect and everything. Most of us women that are the ones that are on this phone call, importantly, we're all very educated women. We all have very good jobs ourselves. You know,
That's not true of all of the gestational
no,
carriers.
it's not, but we're also screened.
But
So
in your
that-
case, they are, but you know, can we say that that's true on every, you know, surrogacy that would ever happen in South Dakota?
There's always one bad seed. Yes, I agree with you. But that was our intent all along from last year, even in 2020 legislation, was to bring forth safe surrogacy bills. And that's what we've been intending to do for the past year and a half. And unfortunately, COVID got in the way and, you know, we were unable to get to do so with each other until about December.
And that's really the hardship right now is we've been working for the last 10 months with Sanford. We've had discussions with Avera, Monument Health, ACOG, different boards of medicine to all come together. Dakota Surrogacy, we've had multiple surrogates, intended parents, even the family who had been one of the first in South Dakota from Aberdeen. We're having discussions with them and their experiences that they had 30 years ago to come together to create the best legislation. To this date, neither of the prime sponsors have talked to any of those people. Avera, Sanford, any of us who you've probably seen our faces a time or two in the last year.
Well, I have. I've been to a number of your things, and
Yes.
you know,
And
I voted, last year to prevent this from going, but this is a much more limited. The bill last year effectively prohibited surrogacy, and this seems to be merely to restrict, to make a provision in a contract that would require abortion to be unenforceable.
Senator, can I speak? This is Jenny Bowe. You've probably seen me. I have spoken with both the prime sponsors, how this would affect my husband and I. We are very pro-life, and we were hoping to put in our contract that abortion could only occur in the event that a surrogate's life is at risk. And I was actually told by both prime sponsors that according to the bill with the current amendment that has been passed, that would make us felons if we were to move forward with a contract that had that provision for the safety of our child, because of some of the language in there. With essentially what it would have to do is you couldn't even mention abortion at all.
Yeah, and I don't read that at all in the contract. The entire provision, paragraph 17, include a provision in a contract that under any circumstances requires a woman to have an abortion or is intended to compel a woman to have an abortion. And then section 2, that, and I don't understand this, but other than a contract for an abortion, a provision of a contract is void and unenforceable if it in any way coerces, compels, or attempts to compel a pregnant woman to undergo an abortion. 2, results in a breach of any term of the contract if a pregnant woman refuses to undergo an abortion. Or 3, results in the pregnant woman assuming any cost, obligation, or responsibility for refusing to undergo an abortion. So where in there can you read any language that if you even talk about an abortion that you're committing a felony?
I am not going to lie. I am not of the legal background. I'm of a medical background. So maybe I'm going to defer that to Emily. I just know both prime sponsors had told me that it would be in violation.
And so the fear is, if you read it carefully or strictly, as a lot of lay people are going to look at it, 17 does say if it requires a woman to have an abortion. And so if it states in the contract that the woman's going to have an abortion to save her life, then that would be a violation, and that's a fear.
I don't see any court would ever construe that way.
Sorry?
I don't see any court would ever construe that way.
You don't?
well,
I hope
like
not. I
there's
hope you're right.
Yeah, just like there's always maybe a rogue person with surrogacy, there could be a rogue judge. And really
Well,
our
I mean,
fear,
that's what we have appellate courts for, if you have a rogue judge.
well, I always want to hope for the best, but what we're trying to say is that we're families who have turned to our attorneys. I have an embryo in the freezer still that I would like to use to give a sibling. Our legal representation is the ones who are reading this bill. And not only that, if that provision would deem our whole contract void and unenforceable, that means all of those other safety precautions. And also, Sanford will not practice surrogacy if our contract is voided.
And
Senator-
again, section 2, and again, I'm looking at which one here? I'm looking at C, says a provision of a contract is void. It doesn't say the contract is void.
Yeah, that was with the amendment C. It changed it, so just the provision. And
And I
Senator
think
Ring,
Amendment A also just refers to a provision, doesn't it?
yes, Amendment A it refers to a provision, but it also removes it as a crime. So instead of it being a potential crime, it would just say that the provision is unenforceable. So I think Senator brings up a really good point of that he's worried and the legislature is worried that the coercion isn't happening prior to the contract, that the coercion could be happening once the contract is in place, once there's a pregnancy in place, and and then at that point a woman could be coerced. And that's something that we would fear too, and we would never want to have. I mean, we're aligned in that goal. No one should ever be coerced to have an abortion. What we would like to just make sure occurs is that there's no potential crime involved, because if there's a criminal statute discussing anything related to surrogacy, it's very difficult for anybody to, especially a lay person who's just Googling around on surrogacy to find out what the law is on it, then they're going to be very dissuaded from entering into a surrogacy agreement because they don't know, am I going to be a felon? Am I going to have a misdemeanor from this? And the way that with the crime language in there, it could be up to a felony 6, which, other felony 6s are arson and child porn. And I think this is very different than that. And then it's actually more serious crime than second-degree manslaughter. So, I mean, it's a very, very dissuasive factor. But I think we can really remain aligned in the protecting any woman from coercion if we just keep it as Senator Roll's amendment, Amendment A, so that it's not, we leave the crime out of it so that people aren't afraid to even enter into a contract. But we make it unenforceable if for that
and I
provision.
realize, excuse me, go ahead.
Okay. I think, so the worry is from our end is, number one, having it in a criminal statute is going to be dissuasive of anyone from entering into a surrogacy arrangement at all. Or if they do, they'll be too afraid to have a contract in place. And if that's the case, then and they still continue with a surrogacy arrangement with no agreement, then there's no protection in there to make sure that the parents are paying for medical costs of the surrogate, so that could leave the surrogate with all these, all these costs of her pregnancy that were just uncovered. And then there's no protection for the child, because if there's no agreement ahead of time of how the parentage would be established, we're worried that that could be like a custody issue that could happen, which all could be preventable as long as we can agree in the contract. But if it still remains that any provision that would be coercive would be unenforceable, then we can still continue with the contract, but knowing that there cannot be any coercive provision in there. So it wouldn't have the dissuasive factor that a crime would have, but it would have the protection that everyone wants.
Okay, what I was going to say is the problem with Senator Roll is we have our consumer protection statute is 16 paragraphs. And then there was a penalty section in there. And then they stuck this paragraph 17 in there, and including the contract requiring a woman to have an abortion falls into the consumer protection. Senator Roll statute proposes to repeal our entire consumer protection statute because as I read that Amendment A of his, it repeals the first 16 paragraphs as well as paragraph 17.
So can you maybe explain that to me a little bit? I'm going to ask a question first. So I was under the understanding that it basically states he's not amending that section because with the current bill, it's amending that section. He's only adding a provision to section 2. So if we're not amending section 1, that would still repeal it. I'm sorry, I'm not nearly as well versed in political pieces.
No, I think that was a good explanation. That's kind of what I was told too. It doesn't actually strip that first section. It just takes it out of the bill because it's an amendment. It has to redline it.
Oh, as Mike, as I'm seeing on the computer there, it's showing 1A3A as striking entirely section 1.
It's just striking it from that particular bill, Senator Rush. It's because it's an amendment of the bill, so it's striking that out of the actual language for the amendment. So, like for example, on my like 188 bill, even though I'm taking sections out of it, or 189, it still shows them, and it shows them with the red line. It wouldn't affect the current law. It's just taking that out of the amendment.
Well, I'm concerned that that's not the effect that it would have. Because if we pass this amendment, then that's the new law, and that strikes those first 16 paragraphs.
Judge,
No,
this is
that's actually, of all people, Lee actually brought that up to me, saying that he laughed at me thinking that was going to be a confusion. It's not. It's because they added that language in the bill in that section, and I'm just taking that section out of our bill. So that section would stay intact as it was, because it's not saying that it's removing it. It's just taking it out of that particular amendment.
I mean, that's the existing law, which is being stricken through, which would.
Judge, this is Brock.
Yeah,
I
Brock.
had this same situation earlier this year. I had a hog house amendment drafted at my own request.
Okay.
And when they show it in context, they show everything that you're striking as a red line, but that just means that they're getting rid of that first element of the language. If the language remained in black and then the line was struck through it, then it would be an actual repeal. But they've presented these amendments in 4 different ways. You've got the HTML version and the PDF version, either in context or like they used to do. So if you look at the other one, that shows the instructions instead of in context, and that shows that they're getting rid of section 1 of the bill. They're not repealing it. They're just striking it from consideration. I have my niece here. She's trying to help out too.
Well, and Brock, you've got a lot more experience with that than I do. That would be my concern, but if you're satisfied that that doesn't get rid of section 1, except for that subsection 17, that's my concern.
Yep, I am convinced of that. So I guess that therein lies the question. You guys have heard some of the discussion so far. You're on that committee. And as far as I can tell, the difference between the Schoenbeck Amendment and the Roll Amendment is that the Schoenbeck Amendment maintains that first section and includes sub 17. The Roll Amendment gets rid of the first section and focuses only on the second element of the bill. Is that accurate? Is that the fundamental difference?
That's my understanding. Yep. Obviously, I'm not a legal expert, but the legal experts tell me that.
And that's my understanding as well, Brock.
So then if we go back to what I think the judge was saying earlier, I've been stewing over this the last several days, and I've spent a lot of time in the last day. Thank you, Lucy. I've spent a lot of time in the last day and a half trying to figure it out. Here, I'm going to put her on camera because she's cuter than I am.
She is.
Yeah. Anyway, the language is pretty explicit in terms of what it does or doesn't allow, and as the judge said, he doesn't think any court in the state would construe it any differently. You cannot include a provision in a contract under any circumstances that requires a woman to have an abortion or is intended to compel a woman to have an abortion. And I think I'm trying to understand this and trying not to conflate it. we're saying you can't compel that. If something would go wrong there, oh, thanks, Lucy. If something would go wrong with the relationship or something like that, the surrogate could choose to carry that child to term if she would prefer. That the couple can't then come back and say, no, you are hereby forced to have an abortion. That's how I'm understanding it. And so I'm trying to, I've been arguing back and forth with the state director of Right to Life all morning and early afternoon here. And I don't think we're terribly far away. I'm not going to kid you. I don't think we're terribly far away from finding something that would work going forward. But, I just want to defer to the judge for his legal expertise. I think the judge was on your side last year. And I think he's very sensitive to the issue. I just want to see if we can't try to figure this out so that nobody feels as though their ox is being gored. Judge, can you go back to that and the effect of looking at the Schoenbeck language, which includes sub 17, as opposed to just striking that and looking only at the role language?
Yeah, I don't know if we need subsection. So there's two parts here. There's the section 17, and then there's the new section 1. And I don't know that we need to have, again, I agree with you wholeheartedly. I don't think we're really that far apart. I'm not sure we need that section 17 if we've got the new section following section. Section 17 provides that putting a provision that requires a woman is a possible criminal offense. Section 1 just provides that the provision that requires a woman to have an abortion is unenforceable. So that's the real difference between those. Personally, I'm satisfied with the section 1 that merely provides that the provision is unenforceable. I don't know that we need to make that into a criminal offense.
I think that was one of the biggest takeaways for a lot of us lay people looking at this, especially the ones that have gone into gestational surrogacy, looking up state bills to see whether or not they're surrogate friendly. The fear was that we would stumble across this and this would be the only statute that we would be able to find. And once you see that word, criminal, felony, so on and so forth, you stumble back and, you're kind of aghast. It really, for me, not knowing much about the legal jargon and everything would make me very hesitant to continue a journey in the state of South Dakota, knowing that somebody could misconstrue something and I could be facing felony charges.
Well, and again, those criminal offense provisions were intended to apply to the consumer protection. And if you read section 17 and then the following one, you end up scratching your head because you don't know what it means. But section 17 include a provision in a contract that under any circumstances require a woman to have an abortion. But then when you get down to the other one, each act in violation of section under $1,000 is a class 1 misdemeanor, and it's all tied down to dollar figures. And section 17 has got nothing to do with any dollar figures. The other ones all pertain to consumer protection where there's actually a dollar figure that might be involved. But section 17 really doesn't. So I question whether it's drafted in a way that makes sense anyway.
That's, Judge, I couldn't agree more with that. I'm sorry, I don't know if I lost you. I lost my picture.
No, I can hear you.
Anyway, I don't see how that necessarily fits in there. It doesn't seem to speak to, there's no consistency by inserting that. But I do want to give deference again to the sponsors of the bill and the ones that are pushing this. I mean, I just don't know if that language is appropriate, if we can't, or I shouldn't say appropriate, but if we can find some level of agreement on some of that language, changing that, getting rid of that section and making it clearer somewhere else might make more sense too. I just don't know.
Brock, this is Mitch. If you just read section 1, if you just consider that the language in sub 17 is not there and was never there, and think about what the intent of the sponsors are, is they do not want to coerce anybody to have an abortion. Wouldn't section 1 meet everything that they're trying to do? I mean, if you just never had section 1 and never knew that that section 1 was there, or sub 17, I mean, doesn't section 1 achieve what you're trying to do as it is?
I want to be clear. You're talking getting rid of subsection 1 and going back to the Roll Amendment, which is subsection, or is section 2 only.
Right.
Is that correct? Okay.
Yeah, with the language that says
with sub 1.
Yeah, with the language that says a provision in the contract is void and unenforceable. I mean, there's no monetary fine or damages there, but I think that does everything that everybody's trying to do if you just forget about 17.
Yeah, I don't know. I think you're right. I mean, I'm not going to kid you. But on the flip side, going back to what the judge had talked about prior, if that sub 17, if section 1 remains in place and sub 17 remains part of this, again, I don't think it makes a heck of a lot of sense to include it in the consumer protection line or section. But if you do include a provision in a contract that under any circumstances requires a woman to have an abortion or is intended to compel a woman to have an abortion, I don't think these surrogacy contracts seek to require or compel a woman to have an abortion. Therefore, I don't know that that's a huge sticking point anyway. And I don't think that a judge would be apt to construe it as such. So I'm trying to find that ground. And as I said, I've been back and forth with Dale Barcher with Right to Life, and I've been telling him, you guys, you need to listen, you need to communicate with these people and hear what they're saying, hear what their concerns are. And he's been telling me, look, we're trying to compromise. That's why the language in the Schoenbeck Amendment included the language in the Roll Amendment, but didn't strike section 1. So I don't know. I mean, I do feel that, Mitch, I think that generally speaking, you're probably right. But if they're hell bent on having section 1 in there, I don't know that it changes the grand in the grand scheme of things. I don't know that things are changed a lot.
To me,
I just don't know. Go ahead.
Yeah. Well, I mean, it just seems to me that if you didn't have sub 17, this is like a guy that wants to wear suspenders and a belt. I mean, you either have one or the other, because 17, if you want to, you wouldn't have to have 17 to accomplish what you want, and that is that the contract's going to be void if somebody's forced or coerced to have an abortion. I wish that was never part of it, because if you just read the 6 or 7 lines that are there, I think everyone would agree that does what they want, and the surrogacy folks, I think, would be fine with that.
No, can I just pipe in for just a minute?
Pipe away.
The things that you guys are seeing, I can see where it's troubling. And knowing that, you know, you haven't gone through it and lived this process is a whole other level of trying to understand a complex thing. I just want to raise a couple concerns that last year, these are the prime sponsors who are very outright about attacking surrogacy. And they're here again. They're also the same men who have told us that we are immoral, that we are sex traffickers, and other heinous things. I'm sorry. I've done good up until this point about not getting emotional, but when we've testified, you have lobbyists there and representatives who simply just don't think this is okay. On record, Representative Hansen has said he would like to see IVF go away. And that's his belief. I would never tell him to believe something that isn't to his core value. But when we testify, we have families in the room. We have our children there. And that's not speaking loud enough.
Well, and go ahead, Liz, sorry.
I'm a little up to my ears that we're telling you the truth. We're not here to end life. We are here doing everything we can to be parents.
And I have been at the Capitol for the last week, and it has been a progressive to the point. I actually had a senator tell me he didn't want to talk to me anymore, wouldn't listen to me. Every single time I came with him, it's not like I was hitting the same pieces. I brought additional information that had come forward after that amendment had been passed. Or in the last week, I've had my morality, my religion. I've been personally questioned as to why I would want to force an abortion. And I am about as pro-life as it can go. But I don't think everyone understands, as an intended parent, the amount of control over your child's life that you are just giving up to a person who's carrying your child. And we just want to do everything that we can to make sure that our child is in the best scenario and as protected as we can possibly be. I'm not a legal person. The last thing I ever want to do is enter into a contract that could be in violation of this. And then my child that I already have, in addition to the child that hopefully we would have, if this contract is found in courts to be in violation of that, then my children, if I'm lucky enough that family members can take them, great. But while my husband and I are in prison, it definitely dissuades me from even considering staying in South Dakota to perform a surrogacy. I mean, I can't put my children's lives at risk. And I would 100% agree with you, Judge. I don't want any woman to be coerced into an abortion. And I really do feel like just the piece that says it's non-enforceable is enough. But if those felony charges stay in place, I would probably look at moving over the border to complete my family, because I can't put my family at those risks. My husband is in the military. He can't get a felony. I'm in the healthcare industry. I can't get a felony. And I know that our lawyers are going to do whatever they can to best inform us. But my understanding with the judicial system is ultimately, though, it does still come down to that judge and their interpretation. And in a lot of ways, laws can be interpreted differently.
Well, but the question I have, the reason I say that penalty provision doesn't make a lot of sense is because it's tied to the value of that was, each act in violation of this statute over $1,000 is a class 6 felony. It'd be over $100,000 would be a class 5 felony. How does being a surrogate, I don't think that applies even. It doesn't make sense to try and tie that in there. That's why I don't think that section 17 really belongs in that place.
So go ahead, Liz.
is last year they really did not like the idea of compensated surrogacy. And compensated surrogacy is anything of monetary value. I believe wholeheartedly that those numbers of monetary value are in relation to the compensated surrogacy contracts, that everyone on this call has a different level of that. Some have been where the surrogate financially declines because that's what they've agreed to. And in some cases, my surrogate did not financially decline because I did not feel, my husband and I did not feel that was what was right for us. You know, when she gives my daughter life, I want to do everything in my power to make her comfortable. So maybe that is buying some maternity clothes. Maybe that is buying other just different things to make her comfortable and happy and to care for her family. I paid for a housekeeper to come and care for her house while she was in the last remaining weeks of our pregnancy. You know, her insurance would not, or her work would not cover maternity leave because it was a surrogacy case, which is a level that I don't understand.
But the dollar doesn't relate to what you're paid for the surrogacy. The act in violation of the section under $1,000. So the provision in the contract that forbids an abortion, how does that tie to the $1,000?
So can I ask a question to make sure I'm understanding this? So you're saying as long as the provision doesn't have monetary value to that piece of the abortion, it wouldn't include the monetary value of the entire contract. So like the medical bills, that aspect, you're saying it would only fall under a felony. Let's say if there was $50,000 awarded, and I'm just throwing something out there, for in the event that she performs an abortion. Is that what you're saying? I'm sorry, I'm not legal at all.
What I'm looking at line 20 there, and it says each act in violation of this section under $1,000 is a class 1 misdemeanor. So what's an act in violation of this section? The act in violation of this section is including a provision in the contract that requires a woman to have an abortion. So how does a provision in the contract requiring a woman to have an abortion have a value of more or less than $1,000?
So the act isn't in reference to the entire contract then? Is that what you're saying? I'm sorry, I'm still not 100%
What line
understanding.
20 says is each act in violation of this section. So it's the acts in violation of the section that's measuring, you know, not the total value of the contract. But that's why I'm saying I don't think that section 17, that pertains to section 17 at all, and it doesn't make sense even to have section 17 in relation to that.
I can probably speak to that. Again, you know, these contracts are very personal, so I really don't want to try to give up as much information on our contract because it's items that Heidi and I discussed at length and we both agreed on. If she had to undergo a DNC, for example, which I believe Senator Haugard called a abortion, if she underwent a DNC, she would need to take off some time from work to recover. And her work would not cover that. Her PTO would not qualify for that. And so her and I agreed that I would basically pay for her to miss work because she had to undergo such procedure because of our pregnancy. That's not going to be a cheap process. I'm going to pay for the process itself because that's what's the best for our surrogate. If our child were to pass away and she had to undergo a DNC, I'm going to be paying for everything to do with that. The trauma, the physical component, the missing work component. So I agreed to pay for her lost wages, time off of work to heal, plus the medical bills of that procedure. So I'm assuming that would qualify.
Well, I don't know that it would, you know, and maybe you can say I'm overly legal, but this, you know, section 17 prohibits including a provision in a contract. So that's what
my contract states that. My contract states that.
But include a provision in the contract that requires a woman to have an abortion. So that's what's forbidden in paragraph 17, a provision in a contract that requires a woman to have an abortion. So does putting that provision in the contract, does that have a value? does that have a monetary value? The putting of that provision in a contract. That's what the statute provides. But I think we're all in agreement that probably 17 doesn't belong there. So I don't know why we're taking time arguing about that. We ought to be talking about section 1.
I would agree there, but again, as being at the legislature this past week, a lot of people are in favor of leaving that section in with the felony charges because they feel like you need to have some kind of consequence for putting this in a contract. So I guess, I don't know if that answers your question. I'm concerned that felony charges is going to stay. Does that make sense?
All I'm trying to figure out here is how this works in function. And I think what Elizabeth is talking about wasn't a provision in a contract that sought to force or compel a woman to have an abortion. It talked about if a DNC is required, if it becomes necessary for some reason, here's how that's going to be dealt with. And that's a far cry from requiring or coercing or compelling somebody to go through that process. And I was really focused on that as I thought about this and thought about what, some of the concerns that I heard last week were. And I think you're dealing with two entirely different elements. So I agree, it's unintelligible. This shouldn't be in section 17 or sub 17 shouldn't be in there. But what if it stays in there? I don't think it does anything. I think that you have a clause that doesn't cost there's no cost associated with putting the clause in there. So it's not going to result in a felony. At some point, a judge down the road is going to look at this and say, this makes virtually no sense to have inserted an abortion statute or an abortion clause in a consumer protection section of code. And so I don't see it as being something that we should fall on our swords over. I guess the one question is if we can figure out a better way to do this, we can potentially counter with another amendment, keeping the Roll Amendment intact, but speaking in some other fashion to this. But I don't know. I don't want to confuse any of the issues. I'm just trying to figure out. I don't think sub 17 is in any way operational. I don't think it's going to be misconstrued as some people have thought. I'd like to see it not in there because it at best makes our law wonky. But if people are going to get wrapped around this, the judge and I can take a whack at trying to get it out of there along with Michael and see if we can't pass the Roll Amendment to get rid of the Schoenbeck Amendment. But I don't know in the final analysis if there's really any difference. I really don't. So anyway, I'll shut up and let other people talk.
And I just say I agree wholeheartedly with Brock. I'm certainly willing to make our effort to try and get the, Mike Roll's amendment rather than Lee's, but I don't think that there's that much difference between the two of them.
So I guess my question is if it's effectively ineffective, because section 17, the penalty won't actually, if there's no monetary value tied to the act, and so actually will not, at most it would create a misdemeanor because that's under $1,000 is my understanding. Do you agree with that, Judge?
I do.
Okay.
If it's under $1,000, yeah, it's a misdemeanor.
But do we want, if we can get everyone to, or all contracts or any provision, I should say, in a contract to be unenforceable, do we even want to have anything in there that could potentially make something a misdemeanor.
Well, if we can get it out of there, certainly I think that would be
Would be-
preferable, but
Yeah,
rather than, as Brock said, fall on our sword over that when it really isn't probably enforceable.
yeah. I mean, I just, my concern is because I work with a lot of, a lot of people who are going through surrogacy, and the number of worries that they have and anxieties are through the roof. And I know enough to know that they're going to see it in this as that there is a criminal penalty, even if it is just a misdemeanor, and that's going to worry them when we can achieve the same thing. So I'm hoping, I don't know if you have any other ideas for another way of compromise, so we can if we can just take the criminal aspect out, it would really mean a lot for some very anxious people who are trying to have their children.
The other
surrogate
question,
too.
now, the other question that I have on that section 17 is who includes the provision in the contract? Is that the woman, or is that the person who's drawing the contract? So it's,
Mhm.
maybe we could make it clear that it's the person who draws up the contract and not the woman who's involved who faces a penalty if there is one.
Mhm.
Since you draw up contracts, are you agreeable to something like that, or is that?
I mean, I don't love it. I'm having a hard time getting attorneys into this area, and we need more South Dakota attorneys willing to be well versed in this, but that's my biggest concern.
Is it as simple as putting in section 1 there, parent 4, a new one, and number 4 that says something about any violation of this of 53-913 is a misdemeanor, or whatever penalty there would be?
I was thinking along the same lines, Mitch, to be honest.
I mean, that would cover, what the penalty is going to be if you violate section 1 there, and then it fixes what 17 is saying.
Could we maybe have some, I'm still really concerned because of the criminal aspect and what it'll do to the lay people and how they look at these things. But what if we can have something in there that describes with more definition what does or does not violate this provision? Meaning if we say something along the lines, and I'm just totally thinking brainstorming here, but if we have something in there that says that a statement of intent of the parties does not violate this, or a provision that specifically cites this law is not a violation, so that they know for sure that under the law, they cannot be compelled. So I'm again, just totally brainstorming us. You guys are the legislators, so you know a lot more about that process than I do.
Well, I think the judge probably has better insights than me on this, just because he's a legislator and he's the judge. So
Mhm.
I would tend to defer to him.
Well, let me give it some thought here. I think there'd be a way to convert 17 into some different language that doesn't result in the woman potentially facing criminal charges, but makes it clear that the person who attempted to coerce her into signing such a contract would be the one who would face the criminal charges. But I'd have to give it some thought to see exactly how that could be worded. And maybe Emily, if you have some thoughts that you wanted to email me too, I could consider that as well.
Judge, as a layperson, would, I guess, what would be construed as coercion be subject to to an individual's interpretation?
Well, eventually a judge would have to determine what was coercion, or in case of a jury trial, the jury would decide what was coercion. And there may be cases that decide what coercion is. I haven't researched that issue here.
You know, that's what's just worrisome to me. I mean, even hearing you guys talk, I kind of was like clouding up a little bit. I'm a teacher. I'm not anything to do well versed in law of any kind. That's why Emily, I stay in contact with her a lot. But, you know, anyone who's on here right now, I think might struggle to see the in-betweens and follow that. And I also would, kind of echo what they've said about the fear of misdemeanor and felony. I'm a teacher. That could be scary. It might steer someone away from South Dakota. We have nurses on here. We have people of, the military background on here. That's scary when you start to wonder, could I be subject to felony and misdemeanor charges? And I also want to just reiterate, we are working as a group, a nonprofit, and we would invite everyone on this call to be at the table with us. When is our meeting with Sanford, our final one? April 6th, 10th? We are in the final stages of drafting legislation for next year. And I know that it's, a little annoying that we didn't get it done, but it wasn't for the lack of trying. I mean, when it came to even surgeries, Sanford had to put people to the wayside to prioritize COVID. So that working with us was not even in their top 20 priorities. But our legislation is going to be down to the detail to protect and all involved, the child, the intended parents, the surrogate. We're going from, you're right, it's alarming, no laws governing surrogacy to try into the first stepping stones. That's why we are working tirelessly with all stakeholders, families, medical team, legal team, everybody to come up with the best safeguards. And as we're passing these, or, considering these laws, that's only going to make this more, alarming. And I don't know if Emily, where we're at with, she's, really the one working directly with Sanford, her and Lisa are, with what we can share about our legislation that we've come up with. But these safeguards are addressed so that we don't have to consider the what if, or the jury that might, make their own interpretations of coercion. Our legislation is going to lay all that out in detail. We're going from no laws to crafty laws.
Hopefully.
You're dreaming there when you think you can prepare legislation that would address all possibilities. And I see Emily is smiling about that too, because she knows that. But I'm getting my handy Black's Law Dictionary out here, and they define coercion as being compulsion, constraint, compelling by force or arms that may be actual, direct, or positive, as where physical force is used to compel acts against one's will, or implied legal or constructive, as where one party is constrained by subjection to other to do what his free will would refuse. Duress and coercion are not synonymous, although their meanings often shade into one another. So, those are the kind of things that a court would look at and a jury would look at in determining whether there was coercion.
So that's coercion to sign the contract? Is that what so that's why I don't understand how this coercion applies into it. I'm sorry. Is that for the signing of the contract, or is it to do something in the contract, or how does that apply in those instances?
I think when I've heard John Hanson speak about this, he just talks about how maybe a couple decides that they're no longer going to stay together, and they are then able to force, because of a condition in the contract, they're able to force a surrogate to undergo an abortion. And he's, he said that should chill us to the bone. I remember his commentary over that, but
Senator-
go ahead.
Oh, sorry. Okay, so my contract specifically addresses that, and I'm sure Emily is my attorney, and I'm sure the rest of her contracts address it as well. And like we did address earlier, there may be a couple of rogue attorneys, but okay, here's the deal with my problem with that situation. One is hypothetical. Two, it's the far extreme. So you have families sitting in front of you testifying about their personal experience, whereas you have Representative Hansen giving you a very, very far-fetched left field hypothetical situation that hasn't occurred in the state of South Dakota in the 30 years that surrogacy has been around. So, every
that doesn't mean it couldn't happen tomorrow if
no,
there's a rogue
it
attorney
definitely
that
couldn't. But when that's why we've been working so hard trying to get some legislation and get some things to protect surrogacy and to protect the child, the intended parents, and the surrogate as well. My contract states that the intended parents, regardless of the deterioration of their relationship, are still financially responsible for that child and will take possession of that child after I deliver that child. Custody, whatever.
Yeah.
Not an
Yeah.
attorney. Respiratory
Right,
therapy.
right. Yeah, no, but it is true that, I learned in the hearing that there are attorneys out there who have done, very different types of contracts from me. And I think that that's something that we'll have to, that actually specifically isn't necessarily addressed in this bill itself as much as just a wholesale in the contract. So I don't know. It's tough for me because I've been, it's a passion, and my CLE is all directed at this. And so I really am a big believer in best practices, but I do understand that it could happen. But it is, legislation on the margin is generally not great legislation. So we'll have to, I'm sympathetic to the legislators' worries here too.
Well, I'll take a look at that and see what I can come up with as far as that's section 17 and see whether we can remove the concerns about criminal liability attaching to the potential mother in that case.
Senator, so is there I'm going to be back in the Capitol Monday. Is there specific talking points that I should look into or consider to bring up some of the top parts you discussed? I apologize. Like I said, I'm not law at all, so a lot of that went over my head.
Well, I think that essentially we're going to try to have Senator Roll's amendment with some revision of section 17 is what I'm going to aim at.
Okay.
If I could give maybe a better whack at trying to explain this than what I have, I think you've got a legislator or two who have heard of crazy situations that have happened. They've got perhaps some examples of language contained within contracts, maybe outside the state of South Dakota, probably outside the state of South Dakota. And they're saying, hey, if there's any chance that somebody can compel somebody else to have an abortion, we need to make sure that doesn't happen. And so
the contracts that Lee had were, and I didn't see them, but he said they were from South Dakota and recently.
And they did say that a person could compel another to have an abortion.
They did.
I don't know. I believe he said
ever actually resulted from that, but that was your understanding too, Mike, wasn't it? That those were South Dakota contracts?
correct. He said there's two of them. I think he said one was 2017 and one was maybe 2015 that were both drawn up in South Dakota.
And who was working on those? I'm just failing to understand.
I have not seen the actual
Is it-
contracts. He told me he gave Mitch a copy, so I don't know if Mitch had time to go through those or not.
You know,
Yeah,
my is
I have the contract. I have copies of the contracts and they are South Dakota contracts and they do say that, but that, as Emily said, I think they're from folks that don't practice in this area often. And, the language is not good, not to our advantage at any rate.
but my question is, did she sign them? You know, I agree with you, those provisions are killing. But my question is can you, Mitch, do you know whose name is on the contract?
Yeah, they're signed. They're not, the copies I have are, I think one of them is signed by both parties and the other one's only signed by one party, but that doesn't mean they didn't have another copy, signed copy.
Do you know the names on the contract?
Yes, I do.
I don't think Mitch ought to disclose that. I think
Yeah,
that's,
I'm not
this
planning.
is live streamed and for privacy reasons, we won't have him name names.
Okay.
So hopefully to help my understanding, the not including subsection C, but Michael Roll's amendment as it's in, would that effectively prohibit this from being enforceable? If we could pass like with Roll's amendment, that would essentially prevent anything from happening with that. Is that correct? I'm just trying to understand how pieces play together.
My understanding of that, and Judge, please correct me if I'm wrong, but is that the contracts would not have been able to been enforceable, but there would not have been a felony, or I guess, as Judge said earlier, possibly a misdemeanor charge attached to them. They would just been non-enforceable in court. But again, I'll defer to Judge because he's the
and that's
judge.
my interpretation. And, I think that's really the goal we should have, is that they're not enforceable. So if somebody did include such a provision in a contract, they could not go into court and try to get a judge to order a woman to have an abortion.
So Judge, can you maybe help me understand what the need is for that additional subsection 17 then? Because I guess I'm still not understanding that. If that other subset takes care of it, as you talked about, why do you feel there's been additional support for including that subsection 17?
Well, and we kind of started out talking about that, but the new section says it's not enforceable. The section 17 says that somebody tries to put that in a contract, then and tries to benefit from it, that there's a penalty for doing that. So it kind of doubles up, but I don't know that we need to double up.
I think it's pride of authorship at this point. I think somebody thought this was a necessary element to put in there, and they're not willing to let it go without a battle.
We see a lot of that.
back. Yeah. I think here's what I think we need to do. I think we need to resolve ourselves to trying to work around the role language, but realize that you've got, a few pretty powerful individuals and lobbies that are working to maintain some element of the language that's in sub 17. So we're probably going to have to figure out a way to word a different amendment to include the role language, but to also give some satisfaction that we're still cognizant that there's an issue with respect to how the contract is drafted that's contained in sub 17. We don't want it in the consumer protection section of code, but we do recognize that it's probably going to have to be in there in some fashion in order to strike compromise and have everybody feel like they've come away with having had their voices heard and everybody's feeling a little bit like I didn't get exactly what I wanted, but it's not as bad as it could have been.
Senator Greenfield, you just described the perfect mediation.
So, and I think I think the judge is on the right track as far as that goes. We can try to bounce back and forth between the judge and Michael and myself and maybe a few others, some ideas. Here's one of the really plain and simple truths too in all this. I was having a conversation with a freshman legislator just a couple days ago, and I said, let's stick together on this 183. And her first response was, but I'm pro-life. And I said, I'm absolutely pro-life. I said, I was the state director of South Dakota Right to Life for a couple of years. I said, trust me, this cuts across more than just those neat and clean lines. So I've gotten her to kind of say, okay, I'll listen to what you have to say and probably tend to follow your lead. But you've got equally passionate people who are just as involved in the pro-life movement, who are 100% they're dug in on the other side, and they feel that they have the best means by which to achieve their goal. I don't think so. I think we can find that middle ground though, working with Judge Rush, and at some point we'll run it up the flagpole and see if the other side won't agree. And then it's really a matter of playing defense on the House side, making sure that it doesn't get twisted around and really messed up and sent back for concurrence, because God only knows what happens then. So if we can all go ahead though, if we can get this figured out in the next 48 hours and get buy-in from both sides and march over to the House with a unified front, I think they're going to say, okay, we're good with this. We're not going to mess with it. And if anybody tries to, they're just going to summarily dismiss it. And that's why this call is so important. And that's why the next 48 hours are just of the utmost importance. So let us, I don't know that there's a heck of a lot else to say. You've got good allies on your side, definitely. We'll be working with Michael and the judge and trying to bring others into the fold. We will come up with language that we think is going to be palatable, and we'll run it past you. We'll run it past Senator Schoenbeck and Representative Hansen and Mr. Barcher from Right to Life, and see if everybody can say, okay, let's go ahead and do this, and that'll give you guys another year. You can catch your breaths from this year and try to get your broader language in place next year, if that works. I know it sounds like pie in the sky, but I've seen things happen like that, and again, 48 hours is very important. You guys did you did a world of good last year and just selling your position. And I think that a lot of that has a lasting effect. So hopefully we can reach out to some of the newbies, get them on board. You guys can keep working your magic with the people, the relationships that you've already harvested. So I'll let you go. I'll let it go at that.
Lisa here, President for Families from South Dakota Surrogacy, and I just wanted to say that first, apologize for my tardiness. I do have a few family obligations that I'm tending to. Second, as I know has probably been stated throughout this entire discussion today, any person going through surrogacy is going through this with the intention of having a child, whether it is the surrogate or whether it is the intended parents that are going to be finally able to have a child themselves. So this is very much a pro-family, a pro-life type of concept. Without having a surrogate, I would not have had a child. Myself, personally, we transferred 2 different embryos and both of them did not make it. I've had 10 miscarriages, well, 8 miscarriages, 1 ectopic and 1 stillborn. Honestly, the doctors have kept saying, I'm not going to be able to carry. So having anything going into me is automatically, going to result in a miscarriage or the loss of a life. So that is why it is so important for us to ensure that our embryos have the best chance of having life by being able to have surrogacy. And we have been reaching out to many different groups, including Right to Life, when we were trying to work on this to come to the table with one unified force, because we know having all sides together makes the best possible legislation. And that's really what we are hoping to be able to accomplish. We are okay with, having some restrictions. We are actually wanting guidelines surrounding surrogacy, because that would provide the protections for the child throughout this entire process, having it documented, which would provide the structure for the attorneys going through it, provide the structure for the surrogates and the intended parents. And that is what we are working on doing. I have reached out to Sanford, Avera, Monument Health, Sadaho, ACOG, Resolve, and the American Society of Reproductive Medicine. Many different groups will be at the table. We will be starting, the tentative date is April 20th, and I'll be inviting as many people if you would like to join so we can work collaboratively, because we have gone over 30 years without having one issue in South Dakota regarding any type of legal case. No person has been forced to have a reduction or any type of abortion in South Dakota. No person has had any type of legal recourse taken from surrogacy. And that is such a wonderful blessing. But it also means that we want to make sure that we continue that. And we are more than willing to make sure that we are working collaboratively with any person to provide that safety. So I just want to say thank you so much. I am very, very excited to have all of you here to make sure that we do have the best amendment coming forward to provide those safety precautions. Because going through this, even though I had an amazing friend, Carrie, for me, I was still concerned. I mean, it is not me. I wanted to make sure that she didn't just all of a sudden saying, oh no, this pregnancy is too hard. I don't want to carry it anymore. It's my child as well, but that safety type of security that you have. And I know it kind of seems like a chance that you can be like, oh, it's just, somebody else can carry it. Personally, I have 19 family members, female family members between that are the reproductive ages between like 16 and 45. 0 of them qualify to be a surrogate. So it's not as if you can just go and ask a friend or family member to be a surrogate, because I have 19 in my family that don't qualify. So that's why it's so important for us to be able to have an opportunity for us to have people outside of just our family to be able to help us, because without it, I would not have my son here today.
I would like to echo Lisa's thank you for being here. I know it's a very complex and emotional thing, and I just appreciate the dialogue, because that really is truly what's going to be at the table to make the best outcome for South Dakotans. So thank you for being here and being willing to listen to us and to help this go forward, but also put in the safeguards that we want as well. So thank you very much.
Yes, thank you for all taking your time to explain the things that lay people don't understand. I know you probably heard the same stories from last year and this year. So just thanks for being willing to listen to our dialogue.
It's our pleasure to do that. I do have one question. Were any of you in attendance at Cracker Barrels today, and what kind of response did you get from the legislators?
This is Jenny Bow. I was in Pierre most of the week, so I was not able to be in attendance to Cracker Barrels at all today. But like I said, when I left on Thursday, it was to the point that the majority of the senators wouldn't even speak with me. I shouldn't say the majority. Several senators kind of got to the point they refused to speak with me. So,
Lisa, I saw you nodding your head. Were you at a Cracker Barrel?
I was able to listen to part of one. I was not able to attend just based on my family obligations that I currently am taking care of. The consensus that I kind of am hearing from it is, again, the concerns that they do not want to have any person coerced going through this, making sure that we are putting the safety of the child first, and also the ensure that the safety and the free will choice of a surrogate going through it. So if we come to the table with with a mutual compromise, I do feel as though we would be able to have many people agree to this as well.
Okay.
I think I do hear a lot of senators, even representatives that I've just slightly touched base with. I haven't focused on them much, just because it's not to their table yet, but have kind of echoed the same sentiment that you spoke to earlier, Senator Greenfield, about how they're pro-life and trying to distinguish and separate the two, and what it entails regarding surrogacy and being pro-life and versus what termination or abortion willy-nilly has been rather difficult.
Sure. Okay. I assume from the silence that nobody else was involved in the Cracker Barrel today. So let's resolve to try to work on this. How many of you are going to be in Pier on Monday?
This is Jenny Bo. I will be there for sure Monday. And then my next week is just kind of, I would like to be, if we can get something proposed over to the House over there to help talk with people on that side and show support as well. But my schedule until I know when and where that's going, but I will for sure be there Monday.
I will be there Monday as well. My schedule out, I'm actually scheduled to work that day, so I'm skipping in and out between outpatients. So, but I'll be there.
I'm planning to be there if I can as well.
Okay. Well, I think all that would be helpful. I just want to thank you for your time today. My niece is coming to rescue me. She must think it's time for me to move on. So with that, I'm going to sign off, but I do really appreciate your time. And Judge Rush, thank you for tuning in. Mitch and Michael and all you ladies. And I said,
Yes. Thank you for being here and enjoy the rest of your weekend.
all right, we'll see you later.
Bye.
Bye-bye.
Bye.
Thank you.